Hey everyone! Welcome back to today's video. This one's going to be a quick watch because we've got a courtroom situation where the defendant keeps making things harder for himself at every turn. But before we jump into that, let me give you a quick preview of what's coming up on the channel this week. First, we'll be revisiting Judge Tammy, someone you all really enjoyed in the last video, as she firmly shuts down another sovereign citizen argument without missing a beat. There's plenty more courtroom drama ahead, so make sure you're subscribed and ready for what's next.
If I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
I'm not sure what that is.
In regards to the right to travel under the 14th Amendment?
Okay, so that's not actually in the Constitution.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified.
Next up, we've got Judge Perkins stepping in to clearly explain why the court absolutely does have jurisdiction, no matter how strongly this self-proclaimed sovereign disagrees. He calmly breaks it down piece by piece, shutting down the argument with facts instead of noise. It's one of those moments where confidence meets reality, and the outcome is never really in doubt.
Mr. Gray, are you trying to get a driver's license?
Your Honor, I'm here by special appearance.
I knew that was coming. Let's just talk a little real simple, basic stuff. Are you trying to say that you can just run red lights, you can just speed, you can just do what you want to do on the roads without any repercussions at all?
Your Honor, is this a court of record? I'm sorry, is this a court of record?
As far as I checked, it was. Mr. Glenn?
Yes, it is, sir.
And to wrap up the week, we've got a completely out-of-control Karen who takes things to the next level by threatening to sue the court if the case against her continues. She argues, interrupts, and pushes every boundary, clearly convinced the rules shouldn't apply to her. It's a tense exchange that quickly spirals, showing just how fast a courtroom can lose order when emotions take over.
So I will be countersuing Romulus, or I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well, because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. They completely ignored my evidence. There was sexual discrimination against me because I was a woman. It would really be a waste of the court's time.
Okay, we're on the record in McNamara versus Sylvester, case number 2018299. The record should reflect Mr. Sylvester has appeared today by Zoom video. We also have Mr. Brzezinski present on behalf of friend of the court. This is set for a show cause hearing today regarding support. And Mr. Brzezinski, can you give me an update on this case?
Yes, Your Honor. This hearing was adjourned from February 6th for the defendant to pay $200 plus stay in communication with the friend of the court if he did not have that ability to pay. He has a support obligation of $363. This is now, I believe, the sixth show cause hearing since June 22nd of 2022. The last payment was August of 2022 at $400. So most of these hearings have not resulted in payment. Multiple times the defendant has been ordered to provide job searches to the friend of the court, which he's done, but it has not resulted in him gaining employment or making any payments. So the friend of the court would ask if he does not have employment or any income, that he provide proof of that, whether it be unpaid bills, rent, proof that he's going to the interviews, just verification of all those details to prove that he truly does not have an ability to pay.
Well, I can tell you that my phones are currently shut off with a past due balance of almost $900, if that counts for anything. And I'm behind on my mortgage. That's $606 a month. Currently don't get an electric and gas bill because something's wrong with consumers. But I can tell you that we're behind in that too. There's only one income in this house, and there is a baby due next month as well. There should be a payment made. I just filed my taxes. I received my state taxes. I know you guys do with income withholding on that. So you guys should be getting a payment from my taxes. I was supposed to get 600 and some change, and I only received $238 back. So there should be a decent payment going to you guys out of my taxes.
Mr. Brzezinski, if the court proceeds with contempt proceedings at some point, would this be a first or subsequent finding?
I believe this would be a first finding of contempt, Your Honor.
Okay. All right. So I'm going to set this for a contempt hearing in April. Mr. Sylvester, there's a couple of things that you need to do under the law. And number one is to make your payments, of course.
Okay, well, I have absolutely zero.
Can you listen to me for a
No,
second?
I'm listening. You guys tell me this every fucking time.
I always tell people it's never smart to act reckless right before walking into a courtroom, but that advice rarely sinks in. So let's slow this down and look at what's actually happening here, because his own actions are making things worse. If he had been paying attention to the friend of the court, he would have heard something important. Yes, he was behind on child support, but they also clearly stated there was proof he had been actively trying to find work. Even though he hasn't landed a job yet, making a real effort matters a lot to the court. That effort showed responsibility and was working in his favor. But then, with one poorly thought-out remark, he managed to undo all of that progress in seconds. And somehow, instead of stopping there, he continued digging himself even deeper.
First of all, don't use that kind of language. You're in a court.
Okay, what are you going to do?
What am I going to do?
I don't come up there.
I'm going to hold you in contempt. I'm going to issue a bench warrant for you to be arrested. Do you want that to happen?
No, but you guys tell me this every time. I have 92 applications out on fucking Indeed right now. I can't help that I can't stop.
I understand that you're frustrated, but this is the second time you've let poor judgment take control. At some point, emotions have to take a back seat to common sense, especially in a courtroom. The judge is now preparing to give you what may be your final warning. This would be the moment to pause, refocus, and actually listen to what's being said. Ignoring this advice could make the situation far worse than it already is.
Mr. Sylvester, based on your language, I've already warned you one time. If you use that language again, I will hold you in contempt.
Okay, well, as I was saying, I cannot help that I can't get a job. Okay, so I've had some places call me back, but it doesn't get me anywhere. I've had 2 interviews out of all of my applications. We've got 1 vehicle, one income. My insurance is actually almost expired because I can't pay that either. I don't know how I'm supposed to make payments when I don't have an income. I don't know how you want me to prove it, but I'll prove it.
Are you done?
Okay, I see where this is going.
Are you going to listen, or are you?
I'm listening. I'm going to get my shit transferred.
Not before things escalate into a contempt situation. The judge has already given you multiple warnings to calm down and maintain control, yet you continued to act as if the rules didn't apply to you just because this was a virtual hearing. That assumption is exactly what caused the problem. And here's the reality of it. You're reacting strongly over something that doesn't automatically mean the worst outcome. Yes, you are behind on child support, and that is a factual issue the court is required to address. Because of that, the court must schedule a contempt hearing. That alone does not mean you are guilty or that punishment is guaranteed. It simply means there will be another hearing where you can present the same evidence you tried to share today. The difference is that it needs to be done calmly, clearly, and respectfully. Handled the right way, this process gives you an opportunity to explain your situation rather than make it worse.
All right. You just used more inappropriate language. So I'm going to, based on your conduct here at this hearing today, I'm going to find you in contempt. I'm going to order that you serve 30 days in the Otsego County Jail for contempt in the view of the court. This is a summary proceeding, and that's based on your conduct here in front of the court.
I'll speak to a lawyer.
I'm going to issue a bench warrant for your arrest. You'll serve your 30 days here once you're arrested and brought before the court. I'm also going to set this for a contempt hearing in April. If you aren't employed and you can't make payments, you need to provide proof of that to the friend.
Okay, how? You guys don't tell me any way how.
Or bring proof of that to the hearing in April.
Okay, you guys want proof, but you guys right here, this is exactly what I'm.
Okay, I'm muting Mr. Sylvester now because I need to be able to make a record and he's talking over me.
Because you guys don't give me a chance.
I gave Mr.
Hey, babe.
I know there are people in his life who depend on him, but his repeated poor choices keep putting everything at risk. He keeps walking himself straight into trouble instead of stepping back and thinking things through. Watching someone fall apart while insisting they're in control might seem dramatic, but the real problem runs deeper. The unfortunate reality is that innocent people are the ones who end up paying the price for his reckless behavior. Family members who had no say in these decisions are now facing the consequences. And choosing to ignore the judge at this stage only makes matters worse. That kind of move won't help his case, and it certainly won't help the people relying on him.
To talk here today, and at some point you have to listen, and you're not doing that, so I'm muting you because I need to make a record. So if you don't provide that proof to the friend of the court at the hearing in April, or bring it or provide it to the court for the hearing in April, then the court will issue or proceed with contempt proceedings, and you could be subject to a contempt penalty of up to 45 additional days. So Mr. Brzezinski, if you can set that for a hearing for contempt in April, I'm going to issue a bench warrant for the court's finding of direct contempt here on the record today, which is a separate issue that you don't need to deal with, Mr. Brzezinski.
Okay, thank you, Your Honor. I will do that.
Like I mentioned, this was a quick and straightforward one to set the stage for the intense week ahead. And trust me, you won't want to miss what's coming next. There's a lot lined up, and things are only going to get more interesting from here. If you enjoyed the video, go ahead and hit the like button. If it wasn't for you, a dislike works too. Either way, drop your thoughts in the comments below, and make sure you're subscribed with notifications turned on so you don't miss future uploads.